We are continuing to dive into the motions in limine that were filed in the Karen Reed case. And by popular demand, we are going to be jumping into the motion in limine that was filed by the Commonwealth, by Hank Brennan, to preclude Karen Reed from presenting a third-party culprit defense. A lot of people are very concerned about this motion, so we are going to be going through this motion and talking about the law as it relates to third-party culprit defense. Now, before we jump into the motion, I want to make something clear, and that is that even if Judge Cannone would grant this motion by the Commonwealth and preclude Karen Reed from presenting a third-party culprit defense, they still would be able to present a Bowden defense. A Bowden defense is different than a third-party culprit defense. A third-party culprit is when you're pointing to some other people that were involved, that they were the ones who committed this murder and not Karen Reed. That is what it's limited to. A Bowden defense is to say that the investigation that was done in this case was not thorough, it was inadequate, it was not complete, they turned a blind eye, they gave certain people preferential treatment. That is still fair game. And in fact, that there's a special Bowden jury instruction which could be requested, when in fact David Yannetti did request this jury instruction at the last trial, although Judge Cannone used her discretion to deny it and not give the Bowden instruction. Nevertheless, she did allow them to argue the Bowden defense. So that whole part about the investigation being inadequate and them turning a blind eye, that is still fair game. So let's just understand that there's a difference between a Bowden defense and a third-party culprit defense. Okay, so now let's jump into the motion. But before we do, again, one more thing I want to mention, and that is that this motion, this brief, is a perfect example of why you actually have to do the research on the case law that they are citing in their brief in support of their motion. If you just read the motion and brief, it seems really solid, it seems really strong, and it would seem that Hank Brennan brings up some very good arguments. But if you actually go to the case law and read the cases and see what they stand for, and see how Hank Brennan is trying to inject that into his brief and support his argument, that's where you're going to start to see that actually some of the cases that he cites is not really supportive of his position, and in fact may be just the opposite. So let's pull up the motion. We'll go through the motion and then we'll talk about the case law. So here we go. This is the motion, Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. Now comes the Commonwealth and respectfully requests the court preclude the defendant from raising a third-party culprit defense. The defense position has chronically been fluid and unsubstantiated. The defense claim has been nebulous from its origin. Karen, just to be clear, and this is the direct question to Karen Reed. Karen, just to be clear, you didn't do it? Answer: we know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know. Seems like she knows who did it. Then continuing on, after the first trial, the defense position began transformation. We're going to retool everything, and maybe some things will stay, some more, but we're going to shuffle a lot of things around. Most recently, in its Fox 25 sit-down, the defense responded to the question, in your opinion, there have been a few names that have surfaced in this third-party culpability theory. Who do you think, if John was beaten up and attacked in that house, who did it? And this was the answer. Defense counsel uttered, we don't know. The defendant quickly echoed, we don't know. Counsel furthered, and it's not for us to know. Somebody other than Karen is responsible for the killing of John. But who it was specifically, others know, and they're not talking. So Hank Brennan showing, first it went from Karen Reed saying we know, and now it's turning into we don't know. All right, let's continue. The evolving responses have vacillated from an unidentified certain villain to not knowing who is responsible, and have been the hallmark of the defense's third-party culprit claims since its inception. The defense is not entitled to simply engage in scorched earth tactics, making baseless and incendiary claims about witnesses without any evidentiary foundation. Prior to the first trial, the court made rulings relative to the defense's third-party culprit claims. The court ordered, based on the offer of proof on Friday, I am well within my rights, pursuant to the case law, to exclude the third-party culprit defense. I'm not going to do that now. I am going to give you a chance to develop it through relevant, competent, admissible evidence, but you cannot open on it. So that is my ruling on that. Despite the court's clear ruling, the defense launched into its third-party claims from the beginning of its opening statement. Karen Reed was framed. That's how David Yannetti started off. Her car never struck John O'Keefe. She did not cause his death, and that means that somebody else did. Followed by, because the Alberts were involved and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit. The evidence identifying or establishing a third-party culprit was never forthcoming throughout the trial, and to this day continues to be non-existent. And then he quotes from the Massachusetts Guide to Evidence, section 1105, and this is the section that talks about third-party culprits. Here we go. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that the evidence has substantial probative value. In making this determination, the court must make a preliminary finding that the evidence is relevant, is not too remote or speculative, and will not tend to prejudice or confuse the jury. If the evidence is otherwise inadmissible, the court must also find that there are substantial connecting links between the crime charged and a third party, or between the crime charged and another crime that could not have been committed by the defendant. Continuing on. After 3 years, the defendant has yet to provide any evidence as to whom they suggest is the third-party culprit responsible for the victim's death, or any evidence of alternative circumstances that would have caused the victim's death. The absence of an evidentiary basis to support a third-party culprit defense was clear before the start of the first trial. To accept the defendant's third-party culprit defense, the court would have to find the defendant demonstrated that the acts of the other person are so closely connected in point of time and method of operation as to cast doubt upon the identification of the defendant as the person who committed the crime. So, again, the acts of the other person that are so closely connected in point of time and method of operation. Continuing on. The evidence must have a rational tendency to prove the issue raised and cannot be too remote or speculative. So you're going to be hearing a lot about remote and speculative. Therefore, the defendant would have to provide evidence of substantial probative value that another individual had the motive, intent, and opportunity to commit not only murder, but vehicular manslaughter and leaving the scene after causing death. See Commonwealth versus Andrade. Let's stop right there. Because what does he say here and what is he suggesting? What his argument here is, very clearly, is that the defendant has to provide evidence of not only motive, intent, and opportunity to commit the murder, but also vehicular manslaughter. I mean, who else was driving a car that night that could have hit John O'Keefe? Or any sort of evidence that that car hit John O'Keefe, and leaving the scene after causing the death. And he quotes this case, Commonwealth versus Andrade, which, if you just read this brief, what it seems to be that he's saying is that if you look at Commonwealth versus Andrade, that would support this conclusion that when somebody is charged with 3 different charges, like Karen Reed is, second-degree murder, vehicular manslaughter, and leaving the scene, that means that your third-party culprit defense also has to present evidence of all 3 charges, not just one. And that would be a lot harder for Karen Reed to satisfy. She can maybe argue that there's a third-party culprit defense for the murder, but leaving the scene, vehicular manslaughter, that's not the argument that she was going to be making if he was beat up in the house. So what type of evidence does she have for that? And here it seems that he's quoting this case, Commonwealth versus Andrade, to stand in support of that proposition. But if you actually look at the case, go ahead and look up this case of Commonwealth versus Andrade and tell me whether that case actually stands for this proposition. The answer is no, it doesn't. It doesn't stand for this proposition at all. And it's very confusing. It could be confusing. There's nothing in Commonwealth versus Andrade that says that you have to prove your third-party culprit defense to every single charge that you are charged with. Even if it's just for one charge, you are allowed to present a third-party culprit defense. And definitely Commonwealth versus Andrade does not stand for the proposition that you do have to do that you do have to provide or present evidence of third-party culprit defense for all the charges that you're charged with. It simply is not existent. That's not what you find in that case. Okay, so that's why it's so important that you actually look up the cases. All right, let's continue. To raise a third-party culprit defense to one charge that is closely intertwined with the other charges would pose a real threat of prejudice by confusing jurors and diverting their attention to wholly collateral matters involving persons not on trial. And here's another quote, Commonwealth versus Rosa, and then again, Commonwealth versus Wood. So if you just read this, it seems the following, that when you have charges that are closely intertwined with each other, that in itself poses a threat of prejudice by confusing jurors, right? And that's what he is arguing this case of Commonwealth versus Rosa stands for. Now, he does bring this quote, diverting their attention to wholly collateral matters involving persons not on trial. He's not going to make up a quote. So that quote does exist. But if you just look at this, I think the simple understanding of what he's trying to say here is that if you look at Commonwealth versus Rosa, it would support this fact that when a person is charged with charges that are closely intertwined with each other, and then you want to raise a third-party culprit defense as to any of the charges, that in itself presents a threat of prejudice by confusing the jurors. And that is in the case Commonwealth versus Rosa. Well, is that true? Well, let's take a look at Commonwealth versus Rosa. Isn't that a good idea? So if you actually look at the case, this is the full quote of where he was quoting. He quoted some of this, but if you see the full quote, you'll be able to see what exactly the case was talking about, and you can tell me whether this has anything to do with being charged with many charges. All right, here we go. Rosa is correct that the demonstration that a third party committed the crimes charged is a time-honored method of defending against a criminal charge, meaning the third party culprit defense. Yet, that trial tactic is, like any other, limited by the fundamental principle that evidence must be relevant. If the defense offers its own theory of the case beyond merely putting the government to its proof, its evidence must have a rational tendency to prove the issue the defense raises, and the evidence cannot be too remote or speculative. Evidence that another person committed the crime charged also poses a real threat of prejudice, especially the risk of confusing the jurors by diverting their attention to wholly collateral matters involving persons not on trial. So you see what he quoted here. He quoted the end, diverting their attention to wholly collateral matters involving persons not on trial. But if you actually see this whole case, this whole quote, look at the whole context of what this case is talking about. The context of this case is talking about, in general, any third-party culprit defense, any sort of third-party culprit defense it could have the risk of confusing the juror. It has confusing the jury. It has the risk of the threat of prejudice. It does. So therefore, when it relates to any third-party culprit defense, you have to make sure that the evidence you present have a rational tendency to prove the issue, and the evidence cannot be too remote or speculative. But this is an idea. This is a holding that is in relation to the third-party culprit defense in general. Nothing to do with being charged with many charges and charges that are intertwined with each other. This has nothing to do with that. This is a general quote about the third-party culprit defense, which is just telling you that the court's telling you that you have to make sure that whatever evidence you're going to point to has a rational tendency to prove the issue that the defense raises, and that it's not too remote or speculative. Okay, so this is why, another great example of why you actually have to look up the case and then see if this actually plugs into the argument that the Commonwealth is making here. So again, read it in context, what he's trying to argue here. To raise a third-party culprit defense to one charge that is closely intertwined with the other charges would pose a real threat of prejudice by confusing jurors and diverting their attention to wholly collateral matters involving persons not on trial. It would seem to me that he's trying to use this case, Commonwealth versus Rosa, to say that when you have many charges that are intertwined with each other, then you can't use a third-party culprit defense because it has a threat of prejudice and confusing the jurors. And the Commonwealth versus Rosa case does not stand for that proposition at all. Okay, so now let's move on to what else he argues here. Additionally, hearsay offered for the truth of the matter asserted that a third party is the true culprit and not within a hearsay exception may be admitted only if. So before we get to the only if, let's understand what that part is. The first part is that when you are presenting a third-party culprit defense, you are allowed to offer hearsay, even though generally speaking, hearsay is not admissible. Everybody knows that. And still, when it comes to third-party culprit defense, you are allowed to present hearsay, even if it's not within any hearsay exception. But there's a qualifier. Okay, so let's get to the qualifier. But that's the first big news of the day, right? Okay, moving on. Only if, in the judge's discretion, the evidence is relevant, okay, so it has to be relevant evidence, will not tend to prejudice or confuse the jury, and there are other substantial connecting links to the crime. So it can't just be the hearsay that's connecting this third party to the crime. There has to be some other substantial connecting links to the crime. Okay, let's continue. The defendant has yet to make a proffer of substantial probative value that any other individual is culpable for her crimes. The arguments previously set forth by the defendant in pretrial motions contain only vague inferences, rank speculation, and scant details of who, if anyone, had the motive, intent, and opportunity to kill the victim. So let's stop right there and analyze this for a minute. First of all, what some people can be thinking about is, what about if you can't point to a specific individual? You can't point to one person. You can't say your third-party culprit defense is Brian Higgins or Brian Albert or Chris Albert or whatever. You can't point to any specific individual. Is that going to be dispositive? Does that mean that you're not able to present a third-party culprit defense? Let's say it's one of three people. Are you allowed to do that or not? And from my research, it seems that, yeah, you are allowed to do that. You don't have to point to one specific individual. So take, for an example, the case of you are in a room with 4 other people and somebody ends up dead in that room and they charge you. Now there's 3 other people in the room, right? You're not sure who it was because the truth is that you were not actually in the room. You were actually outside of the room, but you do know that one of those 3 people were in the room and the guy ended up dead. So he was murdered by one of those 3 people, but you don't know who it was. But you do have clear evidence that they were in the room. Maybe you have some clear evidence that there was some animosity between some of the 3 people and the person in the room, and you have some other evidence that links them. Well, in that case, certainly you would be allowed to present a third-party culprit defense because you know it's one of those 3 people. You don't have to identify specifically which person it is. So let's make that point clear, that the fact that Karen Read cannot point to one specific individual does not mean that she cannot present a third-party culprit defense. As long as you know it's one of those 3 people or one of those 4 people, one of those 5 people, and you're able to connect certain people to the murder, to the victim, and it's not too remote and it's not too speculative, well, then she should be able to present the third-party culprit defense. So let's think, do we have any sort of evidence that would be able to link any of the individuals to the house, which is not just pure speculation or just remote, and that does not connect them in time or place? Well, we do know, right, that Brian Higgins was having some sort of flirty relationship with Karen Read at some point, which cut off, about a week before, right, some few days before. So yeah, that could be some sort of link. There's also the fact that John O'Keefe's injuries seem to be consistent, according to Dr. Russell, with a dog, and a dog was in the house. That can link some people in the house to the murder of John O'Keefe. What about the fact that there were some phone calls between Brian Albert and Brian Higgins that night, which were denied? And then also, what about the newly acquired video of Brian Higgins on the phone at 1:30 in the morning at Canton Police Department? That can also link him to trying to cover his tracks or whatever he was doing on the phone then. So are these things too remote? Are these things too speculative? Hank Brennan would argue yes. And Karen Read would say no. These are things that actually are not too remote. They're not speculative. They link directly to the person. The injuries to John O'Keefe, if they're not consistent with the car and they're found in front of somebody's house who was invited to the house, by the way, by these people, they knew he was coming. That also links them. So are all these things too remote and too speculative to say that there's a third party here? It's one of those people in the house. We don't know exactly who it was. Maybe it's Brian Albert. Maybe it's Brian Higgins. Maybe it's one. So are they able to present this third party culprit defense? And again, that's going to be the argument here. Hank Brennan's arguing that it's too speculative, and the defense here is going to say, no, it's not too speculative. Okay, but the fact that she can't identify one specific individual, or the fact that she's charged with a number of crimes and that she can't prove third-party culprit defense on all the crimes, that doesn't show, you don't see that takes that the court should consider that at all. So that is just something that you'll see from actually doing some of the research on this law. So what's eventually going to happen? I mean, there's definitely more evidence now that they have linking certain people to John O'Keefe. You definitely have that, and you have the videos inside the waterfall or C.F. McCarthy's where they're pretending to box. So you can use some of that. Okay, so this is the argument. The argument is going to be that from Hank Brennan that this is all just speculative. It's too remote. Just because someone's play boxing in a restaurant before doesn't mean that they're in a bar, doesn't mean that that they're going to go commit a murder. So that's going to be the question, whether this is going to be granted or not. So what I'll say is that I think it's still up in the air. It's definitely not clear. Judge Cannoni could preclude them from asserting this third-party culprit defense, but I'm just pointing out to you that some of the case law that Hank Brennan is citing in support of his motion is not exactly on point to what he's trying to prove here. What it eventually comes down to with all these, without all the cases that he's trying to squeeze into this argument, what it comes down to is whether the evidence is too speculative or remote. That's really going to be the question, and that's going to be what the argument surrounds. So that is going to be it on this specific motion. It's not clear what's going to happen. Judge Cannone can definitely say, no, we're not going to allow it. We'll see what she does in this case, but that's what this motion in limine is about. So it's just interesting, definitely, when you actually do the research on this area of law. And again, let's not forget that the burden is still on the prosecution to prove their case beyond a reasonable doubt. It's not because if Karen Reed would decide to present a third-party corporate defense that somehow the burden shifts. It doesn't. There's still the burden on the prosecution to prove their case beyond a reasonable doubt. So that's going to be it in this video with respect to this specific motion in limine. We're going to continue to look at these motions in limine. Maybe we're going to start seeing responses, which are going to get even more voluminous to try to wrap our heads around. But we have a limited amount of time, and we're going to get hard to work, and that's what we're doing here for you. So that's going to be it for now, when we will see you at the next video on the next motion.